As you may now know, the Fourth Circuit Court of Appeals has just handed down an opinion regarding the segregation of bathrooms on biological sex under Title IX. The Fourth Circuit Court of Appeals decided that the word sex really means gender identity, which is preposterous since that concept wasn't even known in 1972 when the law was passed. We're going to have a more in-depth explanation of the court ruling later, but I want to give you this in response to the question, well, what does this mean for us in Tennessee? The fact that the Fourth Circuit Court of Appeals said that the word sex should be interpreted to mean gender identity is not binding on the state of Tennessee. In other words, if you were to ask, David, does this mean that it's a good thing the bathroom bill didn't pass because we would have lost? The answer is no, it doesn't mean that at all. Tennessee hasn't lost anything. Tennessee is not bound by a case that it was not a party to from a circuit in which it's not located. That decision is authority that a court in the Sixth Circuit in Tennessee might use, but it's not binding on the state of Tennessee. So essentially, here's where we are. Our legislators will have to decide in the coming months and next year if we are going to bow down to an interpretation of the Fourth Circuit Court of Appeals in a case we were not a party to, in a decision that we're not bound by, or are we going to say, no, in Tennessee, we really believe the word sex means sex. It does not mean gender identity, and ask our circuit court if our interpretation of the law is correct. So that's where we are. That's what we need to do. But I wanted you to just understand that the Fourth Circuit Court of Appeals opinion is not binding on the state of Tennessee. We can still argue and make the case that sex means sex.